Good morning and welcome to our webinar on protecting your confidential information. My name is Rebecca Sawbridge and I'm head of the Birmingham employment team at Freeths, and I'm joined today by colleagues in the employment and dispute resolution team, and between us we're going to help you to consider questions such as: is the company data your employees have access to safe? Can you protect it against unintentional or unlawful access or disclosure or theft by existing or exiting employees? And what are the consequences of failing to do so? We're also going to include an insight into a real-life case study to help to demonstrate the importance of protecting your confidential information. So we've got an hour for today's webinar, and hopefully we'll have some time at the end for questions. But if we run out of time, we may be able to have a call with you afterwards. So without further ado, I'm going to kick off by looking at confidential information. Next slide. So confidential information is one of the most valuable assets of a business, and it needs to be protected robustly as possible from disclosure or misuse by current or ex-employees and competitors. But not all business information can be protected by law. So we're going to look at 4 types. So the first one, trade secrets. That's at one end of the spectrum. It's a special type of confidential information that is highly confidential. Now, businesses will have lots of commercially sensitive information, but trade secrets are something that's extra special because they're secret in the sense that they're not widely known about within an employer. They've got commercial value because they're secret, and also because they're subject to reasonable steps by the employer to be kept secret. So an example might be something like a secret manufacturing process or a secret formula such as the recipe for Coca-Cola. So the courts have confirmed that employees must keep trade secrets confidential even after their employment has ended, and they will imply a term of confidentiality into the employment contract to achieve this in the absence of an express one. So the next type of information is other confidential information. So that sits below a trade secret. So that could include any information about a business that's generally not known to the public, that's being communicated in confidence and may or may not have commercial value. So an example might be preferential terms of business with a supplier or personnel files. So during employment, this information is treated as confidential, but after employment, it's only protected by an express confidentiality clause, for example, in a contract of employment. So I'm going to come on and talk about that again shortly. The third type of information is skill and knowledge of an employee. Now, that is their own to use and cannot be protected by the employer, even with an express covenant. So you can't restrain a former employee from using their skill and knowledge for the benefit of another business, even if it was acquired during the course of their employment with you. However, general knowledge does not include memorizing confidential information such as customer details, and an employee who deliberately does that to use after the end of their employment will be in breach of their implied duty of good faith. And the fourth type is public information. Now, courts won't generally prevent employees using information that's in the public domain, even if it was once confidential. So whether information is even confidential, and in particular whether it's a trade secret, is often up for debate. There's often a blurred line between mere confidential information, trade secrets, and the skill of an employee. So there are a number of relevant factors that we look at in the categorization of information, and they include things like the nature of someone's employment. For example, whether the employee was accustomed to receive sensitive commercial information in the course of their job. What's the nature of the information that we're concerned about? Whether the employer has impressed the confidentiality of the information on the employee, and whether that information can easily be isolated from other information that they're free to use and disclose. In reality, though, the categorization of information is not typically an issue until a dispute arises, which can often be at the end of an employment relationship when an employee wants to leave and perhaps join a competitor. Next slide. So during an employment, an employee is subject to more restriction than post-employment. So an employer can include express terms in a contract of employment or in an NDA to restrict the use of certain information during employment. An employee will also be subject to a considerable number of implied duties, as listed on the slide. Now, most of those are self-explanatory, but let's pick out a couple. So one of them is the duty not to make secret profit. So this would cover a situation such as not diverting business opportunities elsewhere. So if you're a car sales rep and someone comes into the showroom looking for a 2-year-old family estate car, then you have a duty not to sell them your own 2-year-old family estate car and make a profit at the expense of your employer. Another implied right is not to compete with your employer during your employment. So the issue becomes more complicated concerning steps to compete, but not actually competing with their employer. So an employee is generally free to apply for jobs with competitors or to make preparation to set up their own business, but that has to be during their own time, not their time when they're meant to be working for you. Next slide. So there are far fewer implied restrictions on former employees. If there are no express restrictions, then as I've mentioned, you can only protect what amounts to a trade secret. But with express clauses, an employer can seek to protect other confidential information. So you'll often see quite a detailed definition of confidential information in a contract of employment, covering things like customer details, pricing, strategy, forecasts, etc. Now, there's no need to have a time limit with a confidentiality clause as there is with post-termination restrictive covenants. However, there is some debate as to whether express clauses can protect mere confidential information that's short of a trade secret. So there's been, cases where very general descriptions, such as information relating to the affairs of the company, has been found to be enforceable. But there have also been other cases where courts have applied a narrower interpretation and, for example, found that a clause that covers confidential information about employers' business, products, affairs, and finances to be too wide and uncertain, and so was not enforceable. But I think the dominant thrust of the case law is that a properly defined restriction on the use of information that falls short of a trade secret may be enforceable. And when deciding if the express clause is enforceable, courts will focus on the nature of the information you're seeking to protect, its purpose, and the damage it could do or has done if it were disclosed without authorization. So the takeaway lesson for you is don't rely on a general description of confidential information or include items that are not truly confidential in the lists, because you'll risk throwing the whole of the confidentiality clause into question. So it's important that you define your confidential information as precisely as possible. So don't simply use a pre-prepared bog standard list of confidential items. You need to think about the purpose of the information you are seeking to protect, why it's confidential, so that it can be properly defined and leaves the employee under no doubt as to the extent of their obligations, because you have to remember that the primary aim of the clause is to act as a deterrent. But if someone does fall foul of it, then you want to have the option of taking enforcement if that's a course of action you decide to take. And obviously, having a properly defined clause is critical to this. But ultimately, given the uncertainty over the extent to which the courts will protect mere confidential information, you must do more than simply rely on a confidentiality clause. So, for example, imposing other types of post-employment restrictive covenants to keep employees out of the market or away from customers for a period of time, so that the confidential information that they once knew no longer poses a significant threat to the lifeblood of the business. So we're going to come and talk about that again shortly, but I'm going to hand over to Matt first.
Thanks, Rebecca. So Rebecca gave the example of a trade secret as Coca-Cola and the recipe for Coca-Cola. Now, I don't like Coke, so I'm gonna use Iron Brew instead as an example. I don't know whether it's still the case, but I know famously a few years ago there were only 2 people in the world who knew the secret recipe and manufacturing process for Iron Brew. So let's say that you're in charge of Iron Brew. One of your senior executives leaves, who has access to highly confidential information in terms of recipes, price lists, agreement with suppliers, etc. What can be done in order to protect that confidential information? And we cover on this slide a number of steps that might be involved. The first is, and it's a common initial strategy, is to seek what we call undertakings. And these are likely to be from the former employee, but also potentially from their new employer. And this would be you saying to them, you've left us, you owe us these obligations, will you undertake to us and confirm that in writing that you will abide by your obligations? And the advantages of doing that are it's cheaper than immediately going to court to seek an injunction, and I'll come on to that in a minute. If an employee fails to give a voluntary undertaking, then that may indicate that they are acting in bad faith, and there is something to be concerned about and looked into. A court may look favourably on a party that has made a genuine effort to try and resolve things voluntarily. The disadvantage of an undertaking at that stage is that it is, to a large extent, no more binding than their contractual promise. It becomes different if you do enter into litigation with an individual and there are undertakings given through the court proceedings, and undertakings given through the court proceedings, a breach of those would amount to a contempt of court. So that is much more serious, but that's only when they're given in the context of the legal proceedings. But seeking undertakings can sometimes make the employee realise how serious these issues are, what the potential consequences are, what the legal cost for them might be, and they may voluntarily give those undertakings to you, and that protects your confidential information. The next stage forward, if you like, in terms of seriousness, would be seeking a court injunction to prevent the individual from disclosing confidential information. These are often sought on an urgent basis and also on what we call an interim basis, in the sense that we've not got time to have a full court hearing taking into account all of the evidence, all of the factors, because by the time we get there in 6 or 9 months' time, the damage may have been done. So we seek an urgent interim injunction to say to the court, we're concerned that this individual could cause significant damage to our business if they disclose this confidential information. Will you prevent them from doing so? And there are cases in which courts do grant those types of injunction. And there are cases where, for example, they will order the destruction of information held on computers, and they'll require an individual to put their computer up for inspection by an IT expert, and for the deletion of confidential information from all of those sorts of devices. What often happens, particularly in the case of an interim injunction, is that the court will say, well, what we don't want to do is to give you an interim injunction and then find out when we get to the final case, actually, we were wrong, this information didn't amount to confidential information such that it should have been protected by law. As Rebecca said, there's a fine line between the types of confidential information the courts will protect. And in that case, as a condition of seeking the injunction, the court's likely to seek what they call a cross undertaking in damages, so that if it turns out it shouldn't have been granted, then the ex-employee gets compensated by you for their losses in the interim. And that might mean because they couldn't start another job. So it is a fairly drastic step. The next thing I wanted to come on to and mention was springboard injunction. That's a particular type of injunction where it prevents the former employee from taking unfair advantage of confidential information in circumstances where it's already in the public domain. So effectively, it's saying to them, you can't use it to make a profit, but other third parties may do so, i.e. it can't act as a springboard for your business or your business enterprise. We mentioned their damages. Damages can be difficult to show, but in theory, if an employer is in breach of a confidential information obligation, they're in breach of contract, and you can sue them for damages, provided you could prove the damage, the financial damage that you've suffered, and that the employee can afford to pay those damages. And again, that's why injunctions are often sought in preference to damages, because damages may not adequately compensate you for your loss in terms of a former employee's ability to compensate you for millions of pounds worth of losses caused by breach of confidential information. Account of profits is a sort of form of damages. It's not available for pure breach of contract actions, but it arises where there's a breach of what we call a fiduciary duty, which typically are held by directors and senior employees, or a breach of the duty of confidence. And what that means is, rather than having to compensate you for damages that you've suffered, the individual or the company can be required to give an account of profits, i.e. profits that they have generated through your confidential information have to be paid back to you. So it does happen sometimes. As I say, that tends to be at a senior level where the director owes a fiduciary duty to the company. Final thing to mention on enforcement in this context is rights in relation to databases. So this is a specific regulations that deal with databases that have been created and effectively are designed to say where someone can invest considerable time and effort in creating a database, and someone else extracts or utilizes a substantial part of that database, then that can give a right of action in itself. Next slide, please. Okay. So, having dealt with potential ways in which we can enforce a breach, the reality is what we're often looking at is the old adage that prevention is better than cure. Trying to prevent breaches in the first place, and trying to put yourself in the best position for enforcing the breach, it's worth investing the time and effort at that stage rather than dealing with the expensive process afterwards. And we mentioned on this slide a few ways of dealing with that. The first one is it's fairly obvious, but if there is confidential information, then only give it to a limited number of employees. In the case of Iron Brew, only let 2 people know. Mark things as confidential and private. But you need to be a bit careful with that, because if you mark everything as confidential, then that might weaken your argument that information is sufficiently important as to amount to a trade secret. If the employee says, well, how can they say that was a trade secret and warrants protection when everything I received said it was confidential, and clearly everything wasn't. Some employers monitor use of email, photocopiers, files downloaded, particularly trying to look for employees sending emails to personal email addresses. There are overlapping issues in terms of employee privacy rights, so you need to be a bit careful on that, but that's one way that I know that employers look at protecting their confidential information. Rebecca's already covered having effective confidentiality clauses within contracts of employment or within separate NDAs on particular projects. Again, one nuance to that you may want to think about is if you have exactly the same confidentiality clause in everyone's contract, from CEO down to administration employees, there might be an argument, and someone might challenge it at that stage to say, well, look, how can you be arguing this is a trade secret and this warrants protection if you just put a blanket clause in everyone's contract? So you need to think fairly carefully about how you define confidential information within the context of both your business's confidential information and the role that the employee carries out. We mentioned next, bring your own device or home working policies. We're a long way from the days when, in order to take confidential information, the employee had to pinch the Rolodex off someone's desk that had everyone's customer information on. What we have now is we have a lot of transfer of data between company systems. Some people will use their own phones for company work. People will use their own home printers for printing off documentation. And it's important that if you do have, if people are able to use personal devices and work from home, that you have clear policies in place that govern the security of your information. One, in the hope that people abide by those policies and it will keep your information secure. But two, so that if you are seeking to take enforcement action in respect to that confidential information, you can be going to the courts and you can be saying, this is very valuable confidential information to us. We did everything we could to possibly try and protect it. Here's an example of our bringing your own device policy. This individual breached it by downloading the information or using work on their own device. We clearly told them not to, and this was why we told them not to. Similar to that, in terms of onboarding processes and exit processes, again, in terms of demonstrating to a court how valuable certain information is for you, it's useful to be able to say to them, this is valuable, and you'll see in our induction process for this employee, we impressed upon them what the rules were in relation to customer data, confidential information, etc. And when they left, we went through this process where we required them to delete any information from their personal devices. We required them to return company property, etc. This is all set out in writing. This is what they signed to agree they did, and they didn't do. The final one to mention here is the use of fake customers. And this is something, life's a bit more complicated now, but certainly a few years ago, what we would advise clients to do was, if they had a big customer or marketing database, was to include some fake customers on there. Give you an example. I'm the chief executive of Iron Brew. I include on my customer database or my supplier database, whatever I consider confidential, I might include an invented company that has my mother-in-law's address or email address on it. So that I know if someone pinches my mailing list and sends a generic mailing out to all of my customers, my mother-in-law gets it, and she can tell me, and she can say, I think someone's pinched your database. Now, I appreciate life's a bit more complicated now than it was 15, 20 years ago, but it's something worth considering in terms of trying to protect your data, whether there's anything you can do within those databases to help you identify when breaches have occurred. Next slide, please. Mention here, on a similar topic, looking out for suspicious behaviours, again, on the basis that prevention is better than, and certainly cheaper than cure, to keep an eye out for these sorts of behaviours. I won't go through every one of these. They're all fairly obvious. One of the things I would mention, though, is we have become aware that there are some technological advances in this area, and there are some employers using software and systems to try and identify from an employee's activity both whether there's likely to be a breach of confidential information, but generally whether people are flight risks, whether they're looking to leave. Are they taking off the odd half day here or there, which would indicate they're going to job interviews? Are they sending emails to personal emails, etc.? Now, you have to be very careful. Some of you may have seen in the news last week a decision in France in relation to Amazon's surveillance of workers. So there are data protection issues here and surveillance issues here before you use certain software to monitor employee behaviour. But it is to make you aware of the fact that those are the sorts of things that some employers are doing to try and secure their confidential information. And I think Josh is now going to talk to you about a practical example of our work in enforcing this issue.
Thanks, Matt. Hi, everyone. I'm Josh Middleton, a managing associate in Freeths dispute resolution team based in Birmingham. I'm also joined by Louise Wilson, who's a partner in our dispute resolution team based in Birmingham also. I'm going to be discussing a very interesting and rather quite dramatic case Louise and I were instructed on in 2021. We acted for a major parts supplier in the motor and motor racing industry, which supplies brakes for major racing events across the world, including NASCAR, Le Mans Classic, and Formula One. We'd been instructed as one of our client's employees had recently handed in their notice. The employee was a project engineer, although this really underplayed the importance of their role, which was key to developing the overall brake system. The employee reported directly to the head of engineering for our client. The new employer, who the employee was planning to join, was a direct competitor to our client and its parent company and manufactured brake systems for the use in race cars. Our client was, as you might imagine, very concerned about the employee taking or using its confidential information for the benefit of the new employer. If we could go on to the next slide, Tom, that would be brilliant. Thank you. So the employee's employment contract was well drafted and contained the usual restrictive covenants, which included a well-defined description of what constituted confidential information. So any confidential information in whatever form relating to the business products, affairs, and finances of the company, which had come into the employee's possession or knowledge during his employment with the company. And then the clause went on to list specific confidential information falling within this definition. The employment contract also set out requirements for the employee to return or delete confidential information at the request of our client, and it also contained reasonable restrictions which ran for 6 months from the date on which the employee's employment was terminated, which restricted the employee from, in particular, carrying on or being interested in any business concern in competition with our client within the defined territory, and soliciting or enticing any of our clients' current or prospective customers or our clients' employees. So the employment contract provided reasonably good coverage for our client. Tom, if we could go on to the next slide, please. So to set the scene, the employee joined our client through a grad scheme in 2016 and quickly progressed through the ranks and was made a project engineer after his grad scheme completed. Fast forward to August 2021, the employee gave notice to our clients. He initially told our client that he was moving to a car manufacturer, which wouldn't compete with our client. But as we'll see, that wasn't quite right. So the day after the employee gave his notice, our client sent a letter to the employee reminding him that he remained subject to his restrictive covenants, and in particular that he should not use our client's confidential information in his new role. Later in August, the employee informed our client that he was in fact joining the rival brake manufacturer rather than a car manufacturer. The head of HR for our client subsequently wrote to the employee to inform him that he was prohibited by his employment contract, specifically the non-compete provision, from joining the competitor until his post-termination restrictions had expired. So 6 months from the date his employment with our client ended. The employee didn't respond to this, and we were then instructed to write to the employee to request undertakings, which, in other words, are formal legal promises, like Matt said, that he would abide by the restrictive covenants and not join the competitor until the non-compete had expired. We also wrote to his new employer to request undertakings from them that they would not cause the employee to breach his restrictive covenants owed to our client. At the same time, we asked our client to search their IT systems to check whether there was any evidence of the employee downloading, saving, or sending any of our client's confidential information to his personal devices or accounts or any third parties. Our client reassured us that the employee was, I quote, a good egg, and our client carried out a limited search which returned no results. We'll park this, as we'll come back to it a bit later. You may have already guessed why. So back to the story. The employee and the new employer refused to provide the undertakings that had been requested, indicating that the employee intended to start work with the new employer before 6 months had elapsed. To justify his position, the employee argued that he would be undertaking a different role for the new employer compared to the role he'd undertaken for our client. The restrictive covenants were wider than reasonably necessary to protect the legitimate business interests of our client. And finally, he didn't intend to share any of our client's confidential information with his new employer in any event. So these are broadly the types of reasons Louise and I see in most cases where an employee does not wish to comply with the restrictive covenants in their employment contracts. The new employer, in response to our letter, also tried to argue that they would not receive any of our client's confidential information from the employee and that the restrictive covenants were, in their view, too wide. So, as you might imagine, none of this provided our client with any reassurance or solid protection that the employee would abide by the terms of his restrictive covenants, in particular, the obligation not to disclose or use our client's confidential information, which was of paramount importance in the specialist field of brake design and manufacture. I'll now hand you over to Louise to explain the drama of what happened next.
Thank you, Josh. Thanks, Tom. So as Josh said, the employee and the new employer were very unwilling to provide any form of undertaking that was satisfactory to our client. So we then had to take urgent steps. That first off was a letter of claim. So this was the formal letter that we sent over to them. We sent it to the employee and also the new employer to set out that there were restrictive covenants that the employee was subject to that covered off not only the non-compete for the period of 6 months, but also the confidential information. We set out in that letter those covenants and why we considered them to be reasonable, and also that we considered that the employee held confidential information rather than just skill and knowledge that he'd learned throughout his time working with our client. The response that we got was not what the client was seeking. So the employee and the new employer did respond formally and said that they would give undertakings. However, those undertakings were very limited. The employee said that he wouldn't use any confidential information, and the new employer said that they would not procure that the employee would use the confidential information belonging to our client. However, they didn't give any comfort at all in terms of the non-compete, and it was intended that the employee would start work with its new employer very shortly thereafter. Our client considered that to be totally insufficient. As Joshua said, the confidential information that the employee held was very valuable to our client and would have been very valuable in the hands of the new employer. So we were instructed to issue an urgent application for an injunction, which was an interim injunction that we were seeking, that the employee would be bound to comply with those restrictive covenants and also would have to give up any confidential information that he may have had. It was a flurry of activity, as if anyone's been involved with an injunction before will know that generally you have a very short time frame in which to get everything before the court. And we issued the application, served it on both the employee and the new employer, and we went to a hearing shortly before Christmas in 2021. When we went to court, we made out all of the various arguments, and the court would need to be satisfied in order for us to succeed on 3 different points. First of all, that there was a serious issue to be tried, namely that this wasn't a frivolous claim and that actually there was a reason to enforce those restrictive covenants, and also that the confidential information provision was binding and also would bite on the employee. Secondly, as Matt's already covered off, damages are not an adequate remedy. And if the court found that damages were an adequate remedy, because an injunction is such a draconian remedy that we're seeking, i.e. stopping somebody from working in a particular field for a period, if the court thinks that a party, i.e. our client, can be compensated in damages, they're much more likely to award that. So we needed to show that it actually went above and beyond that, and that what we were actually seeking was to restrict the transmission of this confidential information because it was so confidential. And the third point was that the balance of convenience was in our favour. And again, as I've said, draconian remedy that we're seeking, we had to show the court again that the damage to our client would be greater if the injunction was not given than it would be to the employee by him not being able to work with his chosen new employer for a certain period. The employee and the new employer vigorously defended the application, and it went to a full-blown 2-day hearing. And as part of his defence to the injunction, the employee submitted a witness statement which had an exhibit attached to it. And as we started going through the exhibit, we noticed that one of the pages was our client's internal structure chart of how the engineering team was made up, who reported to whom. And the reason that it had been included was that the employee was trying to show that he wasn't that senior because there were other people who were higher up the chain than he was. However, what they hadn't foreseen was the fact that that document was only available on our client's internal systems. So they must have got access to it somehow, because at this stage, the employee had ceased working for our client. So one of our arguments was, well, you were in possession of a confidential document that you must have obtained and have not returned that document in accordance with your contractual obligations. That then led to a further chain of inquiry, and our client started delving deeper into the IT systems. And what they discovered was very interesting. They managed to identify that the employee had emailed to himself from his work address to his personal email address, first of all, around the time he was giving in his notice, and then subsequently, immediately prior to him ceasing to work for our client, highly confidential information, including Excel spreadsheets that had taken our client years to work on in terms of the results of various testing that they'd done on the parts that they were manufacturing. And in the hands of somebody else outside of our client's business would be hugely valuable. As I say, this led to a huge flurry of activity because we had found what is actually probably the best you'll ever get in litigation to a smoking gun. Because we'd managed to pull that information together, it made our application so much stronger because we could show that the employee did have confidential information and had taken steps to transfer that confidential information from his work email account over to his personal email account. Josh and I then had to pull all of that together for a witness statement for our client to submit, which I think we ended up submitting at 1 a.m. On the day of the hearing, which meant we missed a few Christmas parties that year. When we got to the court hearing, the judge was hugely unimpressed with the employee and what he had actually done. As much as he'd said in correspondence, I don't have any confidential information, obviously that position was completely blown out of the water when we were able to produce these documents that showed that he'd been sending emails to himself of highly confidential information. And I think it was partly that ensured that we got the interim injunction. The defendant then couldn't go and work for his new employer for a period. And we managed to secure an order whereby forensic IT consultants attended at the employee's home and did a forensic image of all of his devices for us to further examine what he'd obtained, and then to go through a process of deleting that so he didn't still have that information to hand. The injunction that we got also had a penal notice on it. So it said if there were any breaches, and as Josh and Matt have already touched on, if you get the undertakings prior to any court proceedings, they are in essence a contract between the employer and the employee. Whereas when you go to court, it then has a penal notice on it. So any breach of that undertaking or injunction then can result in criminal sanctions. So that was hugely important to us in terms of getting this additional penal notice on it. We were then ordered to attend a speedy trial. So normally a case that was going to court with a trial like this would probably take 18 to 24 months. We were ordered to do it within 3 months. So again, quite a hectic period over the Christmas period in 21. But what again helped us was the fact that when we carried out the further forensic imaging by the forensic IT consultants, we then received further data. And when we started to go through that, it appeared that actually the situation was even worse than our clients had suspected. And we even had photographs that the employee had taken on his phone of computer screens in the office and had been sending photographs to himself. We also managed to identify that he had tried to delete information that he had on the morning of the hearing. So not only had he said in writing that he didn't have any confidential information, on the morning of the hearing was then rapidly trying to delete it. I think it was about 5:30 in the morning. So he was clearly trying to cover his tracks. But by the involvement of the forensic IT consultants, we were able to draw a picture to the court in terms of what exactly he had done and how he tried to cover his tracks. We actually didn't get that far, however, because armed with this information, we were able to write to his solicitors to say, we've also uncovered all of this information, which could potentially put their client in contempt of court. I think it took probably about 2 days for them to come back to us to offer to settle and to give us absolutely everything we wanted, including the non-compete for the 6-month period, to give up any confidential information. And we then went through a 3-month process where we reviewed everything on the employees' devices and a deletion process to ensure that all of that confidential information had actually then been safeguarded. The new employer also agreed to pay our clients' costs. So whilst a sort of a stressful and difficult period for them, they were able to ensure that that confidential information that was so valuable was actually kept confidential, and were able to prevent the employee taking that knowledge and using it for a competitor within that 6-month period of his covenants. So really, really interesting case in terms of seeing how it can play out. And Josh will just pick up a couple of sort of takeaways from that case for you.
Like Louise said, that case had a little bit of everything, and we're really pleased to get a good result for our client in that case. There were some really important general takeaways from it as well. So number one, act as soon as possible if there's suspicions of a breach of restrictive covenants. So here we were able to flush out the issues by promptly reminding the employee of his restrictive covenants and acting before he joined his new employer, which if he'd have joined the new employer immediately, that would have made it more difficult to enforce the restrictive covenants. Secondly, always check your IT systems. So I know Matt and Louise have covered it, but we see countless times that employees send confidential information and documents to their personal email accounts, save it to USB drives and similar. I think the most creative I've come across is an employee using his personal mobile phone to take photos of his computer screen. The key message really is securing evidence at an early stage is crucial and puts the employee in a much stronger position when enforcing restrictive covenants.
And then the other 2 points we've got on this slide, again, preserve documents. So whenever litigation is contemplated, then there is an obligation on the parties to ensure that documents are preserved, because that is your evidence that you're going to need going forward. So if you do have an employee who's leaving, who's had a laptop or a PC on their desk, if it's the case that they're normally wiped following somebody leaving, just think through whether or not there's any benefit in just maintaining that laptop, that PC as is, until you've examined and ensured that there's been nothing, no skullduggery going on, or have it forensically imaged. It does incur a cost, but actually if there is a real risk that somebody has done something that you want to stop, then getting that forensically imaged sooner rather than later is a really good step. And finally, challenge the new employer, as we did in the case study that we've just talked through, challenging that new employer, making them aware of the outgoing employee's restrictive covenants is really helpful to your position, because if you later need to pursue that employee, you've put that employer on notice that they could also be in breach of the contract by procuring a breach of the confidentiality provisions, etc. And I think I'm now back to Matt.
Thanks, Louise. So this is a very exciting slide for me. And the reason is, for over 20 years, I've been giving exactly the same advice about post-termination restrictions. The law hasn't particularly changed. There's been a few cases here or there, but the essential nature of the law hasn't particularly changed. It is possible, by no means certain, but it is possible that the law may now change and I may get to give some slightly different advice to clients. So just moving back a step, we've covered a lot about protection of confidential information and confidential information clauses. Because not every case will involve smoking guns as Louise and Josh had, and because proof of breaches of confidential information can be difficult, employers can seek to protect their interests in other ways, and typically those will be post-termination restrictions saying you can't do certain things after you leave employment. And the typical ones would be non-competition restrictions, so you can't work for a competing business, as in that case, for a period of 6 months. Non-solicitation of customers, so you can't go out and try and solicit customers with whom you dealt. Non-dealing with customers, so irrespective of whether or not you've approached the customer, you can't deal with that customer, again, for a period after you leave us. And non-poaching of colleagues, for a period after you leave us, you can't try and entice away any of your former colleagues. Those are the typical post-termination restrictions that we see. And the general law in those areas is that those clauses are unenforceable as restraints of trade, save to the extent that they go no further than reasonably necessary to protect an organisation's legitimate business interests. So for senior employees, it is legitimate, and senior sales employees, for example, you would argue it is legitimate to keep them away from your customers for 6 months. For people in certain industries, and perhaps without the customer connection, but who could cause you damage by going to a competitor, it might be reasonable for you to prevent them going to a competitor for a period after termination. And non-competition restrictions have been upheld by courts in a number of cases as being reasonable. They're not easy to uphold, but they have been upheld. The government expressed concern, and industry expressed concern, that non-competition restrictions in particular, restriction on people finding other job, restriction on the labour market, restrictions on enterprise, etc. We would be a better economy if there was more freedom of movement and people weren't restricted in this way from going to competitors. And the government announced some time ago a consultation about potential reforms in relation to non-competition restrictions. And it had a number of proposals. Two of them, in their response to the consultation, they've now ruled out. The first is they talked about, well, should we require, as some countries do, some other countries do, a mandatory payment for non-competition restrictions? So the employer pays an extra £10,000 to the employee. You agree that you won't compete with us for 6 months after you leave. The government said there were reasons they weren't going to follow that. The second thing they ruled out is a blanket ban on non-competition restrictions, which had been, again, one of the proposals. Should we outlaw non-competition restrictions entirely? They've ruled that out. But what they have suggested they might seek to introduce is a 3-month cap on non-competition restrictions. Now, this wouldn't be a cap on non-solicitation, non-dealing, non-poaching clauses. The existing law would remain in relation to those. But any clause that prevented your employee going to a competitor, you could only restrict them for 3 months. That's the proposal. Whether or not it happens, we don't know. There's still some debate about, and debate from business saying, well, on the one hand, that might lead to greater market flexibility. On the other hand, it makes us more vulnerable to competition. And because of that vulnerability, then we may have to pass on that risk in the sense of higher prices to consumers. So there's some debate about whether or not it will happen, but it might possibly happen. And the other level of uncertainty is we don't know if it were to happen, and we will know, of course, once proposals become more concrete. We don't know if it will happen, or if it does happen, what that will mean in terms of existing restrictions. Will it mean an employee who has an existing 6-month non-competition restriction that is completely invalid unless you rewrite it and get the employee to enter into a valid 3-month non-competition restriction? Or will it just mean that existing restriction is only enforceable up to the 3-month point and effectively rewrites that restriction? So it'll be interesting to see what happens there, what the developments are there. If it is the former, if it is completely invalid and you need to rewrite the contract, then that's going to generate a significant amount of work in terms of issuing new contracts to employees who are currently subject to non-competition restrictions. The other thing that I've seen with some of the commentaries on this issue and worth thinking about now, obviously we'll have a bit of time to plan if this does happen, but some things people are thinking about to try and protect themselves in the event that any law changes. One is to say, well, not to use employee contracts in order to have a non-competition restriction, to make employees shareholders and enter into shareholder agreements in which longer non-competition restrictions might be permitted because they're in a different capacity. The other thing some employers might do, particularly global employers, is have a jurisdiction clause within the contract. At the moment, contracts entered into in this country tend to say any disputes in relation to this contract will be dealt with by the courts of England and Wales. It's possible you might be able to have a longer period of restriction and say any dispute in relation to this contract will be dealt with by another jurisdiction that might be more likely to enforce that. I've even seen some suggestions that particularly sensitive roles might be moved abroad. And again, this is something for the government to have to think about, that if we, as a jurisdiction, aren't going to protect business interests with valid non-competition restrictions, is there a risk that businesses that need these protections, that tech businesses set up elsewhere or move elsewhere where those interests will be better protected? And the final thing to mention as a possibility here is strengthening other elements of the contract. So recognizing that the non-competition restriction might not bite or might not be enforceable, but really strengthening up things like garden leave, notice periods, thinking about length of notice periods, non-solicitation clauses, etc. If legislation is introduced in this area, I'm sure we will hear about it. It will hit certainly the employment law headlines, but in terms of people planning for the future, it's just to flag that as a potential outcome for you. Next slide, please. So the final thing we wanted to touch on today was the issue of data breaches. So these may not be or won't be employees necessarily seeking to take advantage of confidential information for their financial purposes or the financial purposes of their future employers. But it is equally important for you when we're talking about protecting confidential information, is protecting your business against data breaches and the potential liabilities that flow from that. Some of you may recall there was a significant case involving Morrison's 10 years ago, where an individual there who worked as an internal IT auditor, so he had lots of access to their systems, fell out with the employer, was subject to internal disciplinary action, was given a verbal warning for misconduct, so not a particularly significant level of disciplinary action, but nevertheless, he developed a grudge against the employer. He downloaded loads of information onto a USB stick, payroll data for thousands and thousands of employees, bank details, national insurance numbers, took this USB stick home and then posted the information on various data sharing websites, sent it to newspapers, and ultimately was sentenced to 8 years imprisonment for what he did. But Morrison's employees whose data had been breached brought claims against Morrison's, alleging that they should be liable and should pay compensation for the data breach. And Morrison's defended that on the basis that, well, look, it wasn't our fault. this was a rogue employee. There was nothing we could do to prevent him. He was acting outside the remit of his employment. We shouldn't be liable for this. And in the High Court and the Court of Appeal, that argument didn't work for Morrisons. Morrisons were found liable for these data breaches and facing significant sums. Ultimately, when it got up to the Supreme Court found that he was acting so far outside of the terms of his employment that Morrisons shouldn't be liable for his breach, but it was a really, really fine line. And for any employers where they have employees who have access to potentially damaging data, which may be breached by accident or on purpose, it's a real reminder of the potential reputational and financial outcomes for employers. You pop on to the next slide, please. So what we've set out here is some suggestions for managing the risk of that data breach. Some of you will be familiar with these steps. Some of you will already be taking these steps in terms of stress testing systems, limiting the number of people who have access to sensitive data, protecting that data, encryption-wise, password-wise, etc. Training employees on data security and reminding them of basic data protection measures regularly. Again, so one, in order to prevent issues happening, but two, in order to help mitigate the consequences of actions. And then finally, employees knowing who to contact with concerns about accidental loss of data and trying to limit the exposure of data breaches if and when they do happen. So that was what we wanted to say in terms of protecting confidential information, protecting against data breaches. Rebecca, I don't know if we've had any questions in. I'm conscious we've probably only got a minute to deal with.
Well, Sarah's asked if we can send the slides, so we can send that. We haven't had any other questions in that I can see, but I'll pose one for good measure because we've got 2 minutes left. So does getting NDAs signed during employment help to protect confidential information, and can employees refuse to sign them once they're employed?
Yes, so it's a good point about, well, we've talked a lot about putting stuff in the contract of employment. What happens if partway through someone's employment, either we realise we've not protected information that we should have done, or we've got a particular project on where we need to ensure that they keep this information confidential. You can ask employees to sign separate NDAs to their contracts of employment. In order to be enforceable, we would recommend that those are entered into as deeds. We may think about whether or not consideration is offered. So you can do that. My inclination is an employee who refused to do so might be refusing to obey reasonable management instruction and might be subject to disciplinary action. So it is something that can be done and that might be useful in some circumstances.
Yeah, and I would also add to that if somebody refused to sign up to one, obviously they would hopefully explain their reluctance, and you shouldn't be using NDAs for inappropriate purposes. So certainly not to cover up, bad behaviour. So always ask the question: is it necessary? Do we need one in this circumstance? Are we seeking to protect confidential information? Do we already have the benefit of protection through other means, such as data protection legislation? So, question whether one's needed, listen to what the employee says as to why they're reluctant to sign up to it, because as I say, it depends on the purpose in the first place. One last question, I think.
We've got 2 more that have come through, Rebecca, which probably that. So first one, how effective can confidentiality agreements be for recruits that have access to confidential information during the recruitment or interview process?
Yeah, I've seen that done, and I've seen terms of recruitment, particularly very detailed recruitment exercises, seeking individuals to sign up to something that says they will keep confidential anything they've done. Again, potentially it's effective, provided the confidential information is of such a nature that it warrants protection. So if you're going for a job at Iron Brew, you're not going to be telling them in an interview process what the secret recipe is for Iron Brew. You might be letting them know about your management structure, your culture, your values, etc. But I'm not sure they'd be sufficiently confidential to warrant protection.
And then another question, how much do restrictions protect for employees who work part-time?
There's no distinction between whether you're working part-time or full-time. So in that sense, they're not let off. They would be subject to the same restrictions as somebody that works full-time, because again, you're looking at what is the purpose behind the protection, and someone that works part-time is just as easily able to access confidential information or customers and other forms of databases as someone that works full-time. That's it. Any more questions? Oh, I have another one.
So there are employees who do private work elsewhere, so part-time but do private work elsewhere.
Okay.
Yes, so that would be the same point. You could still protect your confidential information in the context of you can't use that confidential information in work elsewhere, and that would be a within employment protection rather than an after employment protection.
Mm-hmm. Okay. I think that's it for questions. So thank you for your time today. I hope you found the webinar useful. Obviously, you've got our contact details on the slide. If anybody's got any questions they want to pose to us after today, then by all means, feel free to reach out to us, and we'll help you to the best of our ability. So again, thank you to everybody today, and thank you also for your time in joining us.